Welcome again to Rich Moyne's production, a Chuck Bruton presentation, in conjunction with ReformCrimeSentencingNow.org. My name is Jerome Deering-Bay. I'm co-founder and program director of ReformCrimeSentencingNow.org. And we're going to pick up from our last episode where we talked about the unconstitutionality of laws that are passed by the Supreme Court or our Supreme Court that are not made retroactive and thus does not benefit every individual who has been subject to a sentence of imprisonment based upon that particular law. So I want to go right to some honor that I want to bestow upon the individuals that have been truly inspiring, and I want to express my gratitude to them for their continued support in inspiring peace and tranquility in my life to speak truth to power. Terry Thomas from Chicago, Illinois, Garnet McCarter from St. Louis, Missouri, Rich Moyne's production, specifically Mr. Chuck Bruton from Des Moines, Diantha Hall from Des Moines, Virginia Jordan Watkins from Des Moines, and Mary Wilson from Des Moines, Wayne Ford, a former legislator from Des Moines, and Pernell Flagg, owner and operator of the Hot Spot here in Des Moines, and Mr. Bobby Pate, Director of Image for Lives here in Des Moines. The views expressed herein are not necessarily the views of Rich Moyne's production, nor the views of ReformCrimeSentencingNow.org. There are individual views in which we're addressing issues that are relevant to our community and to those individuals who are incarcerated. And so with that being said, we're going to pick up from the last episode that we did a couple of weeks ago, dealing with the unconstitutionality of laws that have been rescinded by the Supreme Court of Iowa or the Supreme Court of the United States, and the failure of that law to apply to individuals who have been convicted under those particular laws. And the specific case that we're speaking on is related to Mr. Serretti versus the state of Iowa. The state of Iowa charged Serretti with a first-degree murder in exchange for a lesser charge. Serretti pled guilty to voluntary manslaughter, attempted murder, and willful injury, causing serious injury, and offered factual basis for them at a plea hearing. And we're going to get into that, if not this specific show, but future shows that will follow this show, so that you will understand the concept that is utilized in the criminal justice system. Because you never can tell when you'll have a loved one who is faced with the same dilemma as a lot of individuals still incarcerated, trying to get some relief based upon these laws that are being passed by the higher courts, but are not being rescinded in the lower courts due to one particular word, and that word is retroactivity. Now, Serretti pled guilty to voluntary manslaughter, attempted murder, and willful injury, causing serious injury, and offered a factual basis, and that's a key component which I'll break down later in this particular presentation, for them at a plea hearing. In this appeal, Serretti contends that attempted murder and willful injury convictions entered under the plea agreement, that's something that you sign prior to entering into a guilty plea hearing, must merge with the voluntary manslaughter conviction because the crimes share a common mens rea. And I talked about that during our last episode, mens rea. And that's the element that is essential for the state or the government to prove in order to get you convicted. Mens rea, M-E-N-S-R-E-A. It's not a conjoined word, it's a separated word, as I explained last time during our prior presentation. And that deals with specific intent to kill. The court concluded, under the circumstance presented here, that the voluntary manslaughter and attempted murder convictions are mutually exclusive because one cannot be convicted of a completed homicide and attempt to commit that same homicide without sufficient unit of prosecution evidence supporting separate charges So in all actuality, what the court decided was that the charges that Mr. Soretti was convicted of or pled guilty to had to have separate and distinct charges. They couldn't be combined all into one because the elements are different. Attempted murder is different from murder in the first degree. But they convicted him of all three charges: manslaughter, attempted murder, and murder. And so he was able to raise that issue even after a plea of guilty to the offense, that the charges that he was charged with didn't have the same element of specific intent or mens rea. Because the parties' expectations under the plea agreement, but see, the plea agreement allowed the state to get this off. But his attorney was shrewd enough, whether it was a different appellate attorney, to bring that back because the elements of the charges was different. And that's how he got that relief. Agreement cannot be achieved as a consequence of these mutually exclusive offenses. The court concluded all of Soretti's convictions must be vacated and remanded to the lower courts for further proceedings consistent with the higher court's opinion. Now, why this is critical is Rich Moines Productions and ReformCrimeSentencing.org has had extensive outreach from individuals who are currently incarcerated who are serving these type of sentences on the state level. And Rich Moines Production has been trying to move forward a conversation with state legislators to address the issue as to why this issue hasn't applied to everybody who suffers a conviction under the same scenario that I just set out. But again, previously, I had expressed that the word retroactivity comes into place. That's a court procedure that must be instituted in order for individuals who are not savvy enough, or who are not on direct appeal, or who are not in the Supreme Court pending a hearing on an issue that they might be raising, to bring that issue forward. Okay, now the elections are coming up here in like about 49, 50 days. And this is where our vote is essential to addressing some of the issues that is being discussed across the globe. A lot of things are going on in the world right now. People are distracted, as I stated previously in other episodes, due to inflation, the high rise of gas, the unemployment fiasco, the lack of higher wages, health care, and things of this nature. So we know, being conscious men, that reforming sentencing is not a priority at this point in time. The war in Ukraine, China and Taiwan, all these things come into play, and people are keeping these things out front so as to distract from other issues that deal with our society here in America. And I don't fault them for their concerns about the problems that are being created around the globe. But my focus, and Rich Moines Productions' focus, is to ensure that Congress stays rooted and grounded into reforming some of these laws that disparately affect people that are charged with certain crimes and are unfair and unjust based upon rulings that have been handed down through the higher courts. And I say that because it's not only the legislators' fault that these events occurred previously. It's the individuals who are incarcerated, released from prison, and fail to take an appropriate role into voicing their opinion about how these things are occurring in our society, and then why our society is silent as a whole. Not so much common people, but people who are elected to political office, who have the power and authority to voice our representation That's why it's critical. And there's a thing coming up through Rich Moines Productions here soon that's going to address that particular issue. And I would hope that everybody tunes into that, get involved in the community development programs that are being developed at this particular time to address, our concerns at election. Just because we remain a minority in certain states doesn't mean that minority doesn't have enough power and authority to sway particular votes. So, I wanted to share with you something that most people don't get an opportunity to participate in, and that's the guilty plea process. Now, Rich Moines Production, as I alluded to earlier, stated that he wants to challenge representatives here in the state of Iowa regarding why this law wasn't made retroactive. And I did my best to explain to him that laws are passed, laws are rescinded, laws are declared unconstitutional, and one has to be, that is incarcerated, has to be astute enough and on top of their JOB if they're looking for relief from a law that's being declared unconstitutional. Because I agree with him totally. If a law is declared unconstitutional, that law should apply to everybody who has suffered the ramifications and consequences of that conduct. If it's declared unconstitutional for this man and he gets relief, then every person who has suffered the consequences of that conduct should get relief. But that's not the way the criminal justice system is set up. And I'm explaining to you why. Individuals are sitting in state prison, federal prison right now. They enter into these plea agreements and they have no idea that after sentencing and post-sentencing habeas corpus, that things may come about that allow them to file for relief from something that has been declared unconstitutional. But if they don't follow the relevant procedural aspects of the criminal justice system, the chances of getting relief will be shut out. And that's what's happened to a lot of people that has been charged with these crimes, these dual crimes that have been declared unconstitutional. So I had the fortunate blessing to take and get a guilty plea transcript. And what I want to share with you today is a portion of that guilty plea transcript and try to break down for you why individuals find themselves today in a situation where they're still incarcerated, but yet there's individuals like Mr. Sorority and some of the other individuals who are called in during our show that claim that they have a right to challenge that particular law because it was declared unconstitutional. And we're looking at those cases right now, and I would hope that through the explanation from my perspective will shed some light on why individuals find themselves in that situation. Prior to getting into that, we're going to take a break and we'll come right back to you. Thank you for listening. Welcome back. Thank you for viewing Rich Moines Productions, Gangsters Are Innocents, and ReformCrimeSentencingNow.org, the unconstitutionality of laws that have been rescinded by higher courts and not applied retroactively across the board. Now, before I went to break, I said that I wanted to get into why so many individuals who are incarcerated, 97%, enter into plea agreements and end up getting stuck with sentences that are later on declared unconstitutional based upon the application of the law or a deprivation of a constitutional right. And so what I have for you here today is a guilty plea hearing in federal court. And I want to share that with you, and I'm going to break this down for you from my perspective so that you can get a clear understanding of why individuals find themselves post-sentencing in a position to that very few of them get relief because they waive their constitutional rights. And that's one thing that Rich Moines Productions and Reform Crime Sentencing has alluded to throughout these presentations on a site, and that's .org and Facebook, and we would hope that through the presentation of these events, that family members and those individuals who are afforded an opportunity that are incarcerated will get a clear understanding on protecting those particular rights. Like, again, prior to going to break, I alluded to the fact that a lot of people have reached out to us about this particular issue. We have people in the local jails, we have people in jails throughout the United States who are contacting both offices and inquiring what they need to do, seeking information that they need in order to ensure that as they consider entering into a plea agreement, that they protect certain constitutional rights, so that if something comes down later on down the road, if in fact guilty, they can receive a benefit or are capable of getting back into federal and state court and arguing for a lesser included offense. And that's what Mr. Cerruti did. Now, we had an individual call the show on our last episode, and he suffered the same consequences that Mr. Cerruti did. The only thing that he fell short on was he waited too long to file that particular motion. And so subsequently, he was released from state prison, and he's now out here, and he's saying, well, I should have got the same relief that Mr. Cerruti got. Well, he might have got that same relief, but he didn't find out until after the fact. And so that's what I mean by being conscious, being aware, like, staying caught up on events that are relevant to your freedoms and your liberties as protected and guaranteed under the Constitution. So, with that being said, like I said, I had the benefit of receiving I got a lot of these, a guilty plea transcript. And I want to take you through that and break the guilty plea demonstration down to you so that you can see the difference between defendants, how some get relief and how others don't. And so, this particular case was out of Missouri. Missouri is located on the federal level. And this Missouri is located in what is called the 8th Circuit Court of Appeals. So, just like Minnesota, Iowa, and Missouri, on an appellate level, they all fall up under that circuit court. And Clarence Thomas happens to be the highest ranking judge over that particular circuit. So, you might want to make note of that. Each judge that sits on the Supreme Court, United States Supreme Court, is over a particular circuit. Clarence Thomas is over the 8th Circuit Court of Appeal. Okay, this is a case that happened in United States District Court for the Western District of Missouri. An indictment reads just like this so that you understand. United States of America, they're the plaintiff, versus the defendant. Okay. The transcript will read, or the guilty plea hearing record will read, transcript of a change of plea proceeding. Now, what does that mean? That means that the individual, when he first went into court, pleaded not guilty to the charges. Subsequent to that not guilty plea, he decided to plead guilty. So, through the process of his attorney and the government attorney, they entered into what is called a plea agreement. A plea agreement is something that the defendant, the attorney, and the prosecutor and attorney all initials and signs. You initial and sign that because that's the contract that describes what the guilty plea is going to be predicated upon. Then, in a matter of time, they're going to bring you into a federal court. You can go into that federal court, and the court is going to have a hearing under Federal Criminal Rules and Procedures, Rule 11. That rule is what describes the taking of a plea. That's a federal rule. Now, it's my intent to share with you how that process goes as far as a guilty plea hearing. At a later date, if necessary, we get enough inquiries as far as a plea agreement that precedes the actual guilty plea is concerned. The plea agreement is an essential part of the guilty plea because everything that you're going to plead guilty to, is part of that plea agreement. So you need to be conscious of that. And any competent attorney will tell you that if in fact you have loved ones sitting in the county jail, the city jail, whatever, pending a federal or state charge. All right. And what the court does at that particular time is he asks the parties, that's the defendant and the government, if they're ready. The attorneys answer, we are ready. Okay, the court asks the defendant, would you please stand and raise your right hand and receive an oath from the clerk, which the defendant is required to do. The court would then come back and say, you can be seated. And the court would then address the defendant's attorney and say, is the defendant desirous of entering a plea to one or more of the counts charged against him? And the attorney will respond, he desires to plead guilty to all counts against him in this particular case. So the defendant was charged with, I think, 4 different crimes that were subject to a wide range of punishment. All right, the court says, thank you. Do you understand? He's addressing the defendant. You are now under oath, and as a result of that, if you were to answer any questions falsely, your answers could later be used against you in another prosecution for perjury or making a false statement. So, in other words, what the court is explaining to the defendant, if you get up here after raising your right hand and taking the oath of the court and tell perjury, and the government deems that you have perjured yourself, or there's evidence to that, they can come back after all this other stuff that you was charged with in the initial indictment and charge you again with perjury, which is an additional 6 months in prison. 6 months is 5 years. In the federal court, they talk about months. They don't talk about years. And I don't know if that's to lure you to sleep, to think that you're getting less time or what. So they'll say 60 months instead of 5 years. Or they'll say 360 months instead of 30 years. And so some people might miss that. So we need to be conscious of the dialogue that is utilized in a criminal court proceeding. And a lot of us are not. A lot of us is new to this. We're just out there, doing what it is that we do, not realizing that when we enter into the criminal justice system, you're on a whole different playing field. The dialogue is totally different from the dialogue that you utilize in the street. So if you don't have the appropriate dialogue, if you don't have the appropriate understanding, if you don't have the appropriate education to understand the dialogue that's being spoken around you, you don't know what's occurring. You simply guess. You simply go off of what your attorney is telling you. You simply go off of what the prosecuting attorney is telling you. You don't understand the intricate details of law. And that's where we're held at a disadvantage. And that's why we try to do our best to educate families, incarcerated people, and those who have a common interest in the criminal justice system to understand the intricate details of that jargon so that they can protect their constitutional rights, so they're not abused by the law, because so many of us are. There's a difference, and in later shows, I'll explain that difference to you. With that being said, I'm going to move forward. All right, thank you, defendant. Do you understand you are now under oath, and as a result of that, if you were to answer any question falsely, your answers could later be used against you in another prosecution for perjury or making a false statement? The defendant answers, yes, Your Honor. The court, would you state your full name for me, please? And the defendant states his full name. The court asks, how old are you? And the defendant tells him how old he is. How far have you gone to school? The defendant said, I got my GED. He doesn't have a law degree. He ain't been to college. He has a GED. But now he's in a system that deals with law degrees. Makes a big difference. Okay, with that being said, have you been treated recently for any mental condition or mental illness or addiction to narcotics? The defendant, no. Are you currently under the influence of any drugs, medication, or alcohol beverage of any kind? The defendant, no. Have you received a copy of the indictment? That's the first initial step. In certain cases, they'll file a complaint against you. And I would advise any defendant, never plead guilty to a complaint. Make them indict you. Don't plead guilty to a complaint. A complaint is not an indictment, it's just a complaint. And there's a distinction there, and a lot of people don't know that. Moving on. Which contains the charges pending against you in this case. The indictment is subject to constitutional guarantees. The complaint doesn't have those same type of guarantees. So you don't never want to plead guilty to a complaint. You never want to take a complaint to trial. You want to take an indictment to trial under due process, your Fifth Amendment constitutional right. The defendant, yes. Have you had the opportunity to review the charges against you as well as review and discuss the case in general with your attorney? Most defendants answer that question yes. Because during a guilty plea hearing, you're required to follow the script. Your attorney has already come in there, he's already told you what you're looking at, 20 to life. That's the statutory provisions of this type of offense that this particular individual was facing. 20 to life. So, this is what you're subjected to. The attorney's going to tell you where you'll get the minimum mandatory offense, 20 years. Or you might get 30 years. But you're not going to get no more than that. But if you don't take this case, if you don't plead guilty to this case, you're going to end up getting a life sentence based upon your prior criminal history. And we'll get into that later. You had the opportunity to review the charges against you as well as review and discuss your cases in general with your attorney. The defendant, yes. The court, addressing the attorney, addressing the defendant, has done everything you have asked him to do as your attorney in this case. The defendant, yes. Now what's relevant about the court asking the defendant that particular question is now the court is going to protect the attorney against a claim of ineffective assistance of counsel under the Sixth Amendment. Meaning, if this defendant doesn't waive his constitutional rights to post habeas relief or appellate relief, and he finds the error throughout this process, he can bring a claim up that his attorney was ineffective and gave him bad advice or misadvised him about a particular point. And that's essential in this process. So what the court tries to do is to alleviate any post-conviction petitions being filed along this line. So he gets the defendant to admit on record, unbeknownst to the defendant, because the defendant don't know nothing at this particular time. All he's doing is jumping through hoops that his attorney has provided for him. So he don't know that what he's entering into may have constitutional issues attached to it that he can preserve and argue later on down the line and maybe get a 30-year sentence up off of him or a 20-year sentence up off of him or a 10-year sentence up off of him or a life sentence up off of him. He don't know this at this particular time because he's so shook up going through this process and hasn't taken the time throughout sitting in jails, because they're not getting bonds, but throughout sitting in jails, to take the time to go in there and check behind everything that's being told to him, to get a basic understanding of his basic rights and the basic law that is being applied under those rights so that he can protect himself. He is browbeaten to the point that he believes that he has no other choice but to depend on this attorney to represent him effectively, as most of us did. I mean, this is a system that we believe in. But again, that's not always the case. And over time, you learn that. So, moving on. Okay. Yes, sir. Is there anything that you did not want your attorney to do that he went ahead and did anyway, you believe he should not have done? The defendant, no. Now, at this point, the defendant has very little understanding of what was done and what wasn't done, what could have been done and what couldn't be done. Because again, he didn't invest the time that he spent in jail waiting to enter into this plea or go to trial to check behind everything that was being told to him and everything that was being given to him as far as documentation was concerned. He didn't do his due diligence. And failing to do your due diligence is a costly mistake in the administration of justice. Because later on down the line, you can see glaring errors, but you can't correct those errors because of the procedures that are in place, like Rich Moyne's production brought up, dealing with the unconstitutionality of laws that apply to one defendant but don't apply to the broad spectrum of defendants who have been convicted of the same offense. So they still sit in prison while one defendant receives a benefit. And the defendant that received that benefit was astute enough and had the proper attorneys. And as Rich Warren's Productions pointed out, this guy was a rich farmer. So he could afford to make sure that his defense was intact. And he may not get the relief he wants at the guilty plea, but because he had enough finances in order, later on down the road, he could get back because he had finances to do that. And even in the criminal justice system, it takes finances to get freedom and liberty, to enjoy the liberties that are accorded to you in the United States. It's not free. So if you got a court-appointed attorney, don't think that a court-appointed attorney is going to do the same thing for you unless he's extremely hungry and trying to make a name for himself. And there's a rarity there. And there are some that do that. You know, I'm speaking truth to power. There are some that do that. But they're rare. They're rare. And most of them just follow the status quo. The assembly line prosecution. Next client, next client, next client. Guilty, 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 guilty. So, is there anything that you did not want, I said that. Do you have any questions, concerns, or complaint in relationship to the legal advice or legal representation that your attorney has provided for you as your attorney in this case, the defendant? No, Your Honor. He doesn't have the wherewithal to ask the question, what was my attorney supposed to provide for me? What was he supposed to advise me of? How do I know? I'm not an attorney. I ain't been to college. How do I know what he was supposed to do for me? And I have no knowledge of this. You're telling me that to understand the law, you got to spend 8 years in college. I ain't spent 1 day in college. So the questions that a court is asking the defendant is, I mean, to me, it's just, ridiculous. Because how can a defendant honestly answer a question like that, and that defendant doesn't have no understanding of the law themselves? They don't even understand the constitutional right. So how do they know that that right is being accorded to them? But this is what the court's asking them. And the court is asking them based upon the script. And the script is to ensure that the guilty plea that this defendant is holding up to holds, that he can't come back later on down the line and rescind that plea. Because he answered every question like he understood everything that was going on in that courtroom. And that's the defendant's undoing. Are you fully and totally satisfied with the legal representation and legal advice that your attorney has provided? The defendant. Yes, Your Honor. And has anyone made any promises or assurance to you of any kind in an effort to cause you to enter a plea of guilty in this case? No, the defendant. Is it your desire to plead guilty of your own free will because you are in fact guilty of the charges against you? Ain't but two things to get caught by the mouth. A partner of mine told me this a long time ago. A fish and a food. Yes, Your Honor. And do you understand counts 1, 2, and 3 are all felony counts? Yes, Your Honor. Do you understand, defendant? If your plea is accepted, you will be adjudged guilty, and you may thereby be deprived of valuable civil rights, such as your right to vote, an issue that we'll be speaking on here within the next 30 days, your right to hold public office, your right to serve on a jury, and your right to possess any kind of firearm. The defendant, yes. Do you understand, defendant? Under count 1, if you are found guilty, you are subject to a range of punishment by way of imprisonment of not less than 10 years up to life imprisonment. Yes, Your Honor. Do you understand under count 2, you are subject to a range of imprisonment of up to 10 years? Yes, Your Honor. And do you understand under count 3, you are subject to a term of imprisonment of not less than 5 years consecutive? That means any sentence that he gets on count 1 and count 2, the third count automatically is a consecutive sentence. So if you get 360 months on the first sentence, which is 30 years in prison, there's no way you can get around count 3. That's a consecutive sentence. So after you serve the 360 months, you still got to serve that 5 years, because not aligned with count 1 and count 2. It's consecutive to it. That means so you're going to serve the 360 months first, then you got to come back and serve another 5 years after that fact. So in all actuality, you're serving 35 years. You'll serve the 360 months first. You'll discharge that sentence. Can't get out on parole. Can't get no halfway house. You can't get none of the community releases that are incumbent upon the First Step Act or any of the Equality Act or any of these other acts that are being passed now. You got to do can't get no halfway house. You got to do the 360. After you get through with that, 25, 26 years. After you get through with that, then you got to come back and do another 60 months before you can even be considered for release. And you're like this here, you're thinking, oh my God, I can do this 360 months, I can do 25 years, and I might be able to get out. And then when you get done with the 360 months, you got another 5 years to do. Come on, man. And do you understand in the count 3, you are subject to a term of imprisonment not less than 5 years consecutive to any term of imprisonment on counts 1 and 2? The defendant, yes. And do you understand on the count 1, you could also be required to pay a fine of up to $4 million, and in the count 2, a fine of up to $250,000, and in the count 3, a fine of up to $250,000. Yes, Your Honor. And do you understand that under count 1, upon your release from any period of imprisonment, you could be required to serve a supervised release of 5 years. And that supervised release under counts 2 and 3 could be up to 3 years. Yes, Your Honor. Now, some women have contacted the Rich Moines Productions about their supervised release and parole status. And that's an issue that we hope to get into in our future broadcast. And that's essential because there's a lot that's tied to supervised release and parole. And some individuals have more time in prison than, more time on supervised release than others. And that can be a very tiring experience from an individual that has done a lot of time in prison and then still has a lot of time to do on parole or supervised release. And that's a topic that we're going to take up in a future presentations, and I hope that our viewers tune into that. And do you understand, defendant, if while you were serving those terms of supervised release, this is critical, your supervision was to be revoked, that you could be returned to prison for up to the full term of your supervised release without being granted any credit for the time you have already served under supervision? Meaning, you've done 25 years on a 30-year sentence, you're going to do 3 years and some odd months on the consecutive 5. You got a 5 or 8 or 10-year term of supervised release. If you come out here and you can't deal with society and run amok and get revoked, you're going to go back to prison, and the judge can revoke all the time that you've done on the street and make you do that full 5 years. So what you end up doing, in all actuality, is a 40-year sentence. And that's why it's critical that the apparatuses that are in place, as far as community reentry programs and things of that nature, afford and accord individuals that are coming out of prison some guidance so that they can effectively deal with the advances that have transpired during the time that they were incarcerated, especially for a person that has done 15 years in prison, 10 years in prison, 20 years in prison, or longer. Because those people that are coming out of prisons are really behind the times. And doing a nonviolent offense, there should be things in place to adequately and effectively ensure that they have the opportunities there to ensure that they're successful upon these releases. We don't want to keep having taxpayers to pay for costly incarceration just because we don't have in place apparatuses and opportunities to assist individuals that are coming out of prison. And so, again, that's why we're taking you through the exercise that we're taking you through so that we can give you a breakdown on the pros and cons of this process. And hopefully you're gleaning something from the description and the illustration that I'm providing and Rich Moines Production is providing through this podcast. Welcome back. As we were talking about before we went to break, we're talking about a guilty plea hearing. I'm just giving you the basic procedure in which a defendant goes through during a guilty plea. And what we're going to do is we're going to tie this into the unconstitutionality of laws. And the foremost case that we used was a guy by the name of Hemster, who got the case in the Iowa Supreme Court overturned, and individuals who followed him couldn't get relief on that. We're addressing an issue that was brought to our attention by Dante McKinney, I think, better known AKA as G-Nut, who suffered the same type of consequences that Mr. Hemster suffered. Hemster relied, if I'm not mistaken, on the Soretti case. That's why I cited Soretti, because it appears that Soretti set the standard, and Hemster followed him and got relief on his case. And other individuals are currently incarcerated in the Iowa State Prison for murder with lesser included offenses, have not received that benefit. And that law was declared unconstitutional. So we're trying to shed light on the process of how some individuals can receive a benefit from prior precedent coming down from the Iowa Supreme Court or the United States Court of the Supreme Court. And but the first phase of all this is going through the process that I'm reading to you now, which is a guilty plea hearing, and how individuals waive rights that can protect them, because unbeknownst to them, they have no idea that laws do change, constitutional rights are challenged, and higher courts rule in favor of defendants, and defendants can receive relief based upon the unconstitutionality of certain laws, if in fact those laws are declared to be retroactive. In most Supreme Court cases, in Iowa Supreme Court cases, the court never rules on retroactivity, because that's not a question before the court. But if prior precedent dictates that result, I'm talking about the result of retroactivity based upon the standing of the precedent, individuals can utilize that precedent to still get relief. But a lot of individuals incarcerated are unaware of this. So the kind of waiver in pursuing the processes that are available to them to gain the benefit that Mr. Hemster gained by following the doctrine of Soretti, and that is to challenge what appears to be a rule or a procedure or an application of the law that has and is been declared unconstitutional. So, moving on with this guilty plea hearing, and defendant, do you understand if your plea is accepted, you will be required to pay the government a special assessment in the amount of $100 for each count, which will be a total of $300. And the reason why a court imposes the assessment is the court knows that most defendants can't pay the $1 million or $2 million fine restitution that they're going to impose. So they don't pursue that unless there's assets clearly identifiable that supports that you can pay those type of fines. If in fact the court realizes that you're out here selling dope and you ain't really getting no money, you don't own no car, you don't own no house, you have no other assets, there's no evidence to support that you was a profitable drug dealer, they're not going to tax you with a fine or restitution. They're going to make you pay the assessment on each count that you plead guilty to. So that's $300 in this case right here. Now, moving forward, the defendant, yes. Defendant, do you understand that in determining a reasonable and appropriate sentence in your case, the court will consult and consider the United States sentencing guidelines? Yes, Your Honor. And you understand that those guidelines are discretionary. And while you may be sentenced to a term as suggested by the guidelines, listen, this is critical, by the guidelines, you could also be, even though he entered into a plea agreement, sentenced to a term either less or greater than what the guidelines otherwise recommend. The defendant, yes, Your Honor. So he's locking himself in. The defendant is locking himself in based upon the way the court's questioning, unbeknownst to the defendant at this particular point in time. Because the defendant believes he's going to get a particular sentence. Unbeknownst to him, the court then already made him aware of the fact, I can go less or I can go higher. That's hope for the defendant, because he's believing what his attorney and his government attorney told him what they would recommend as far as sentencing is concerned. But the court can disavow all those recommendations and sentence him based upon the guidelines, lesser or higher. So if your guideline range says 360 months to life, he can give you life, because that's what the guidelines range say. He's going to consider the factors of that probation officer's report and the factors surrounding your indictment and your guilty plea and the conduct that ensued during the criminal conduct that you either participated in or didn't participate in. 9 times out of 10, if you pled guilty, you participated in it. So he's going to consider that. Then he's also going to consider your criminal history. So if you have a violent criminal history and your guideline range suggests 60 months, the court's going to look at your criminal history and say, well, you got a violent past. You've been out here doing crimes for 20, 30 years. You've been doing everything under the sun. We done gave you chance after chance after chance. And I'll break that down to you when we get into the sentencing transcript, how a court utilizes that past to increase your guideline range or to give you the statutory minimum of 20 years or 30 years because it's due to your past. A sentence that you had already served, paid your debt to society, but now they're going to utilize that to increase your punishment because the court's going to say you haven't learned your lesson. But that's a story for a different day. And you understand, defendant, in determining the application of the sentencing guidelines, the court will make all, you didn't say nothing about what your attorney and the government entered into. The court said this. It said, in determining the application of the sentencing guidelines, the court will make all factual determinations necessary on the basis of a preponderance of the evidence. And what the preponderance of the evidence means is that you're not protected under due process because you waived your right to a jury trial. So under the preponderance of the evidence, anything that is said in a court of law, anything that is written and entered into evidence at the guilty plea hearing and at sentencing can be considered under a preponderance of the evidence. And what that means is he don't care if anybody testified to the contrary. It's what he believes or she believes if they're a judge on whether or not you should be held accountable to that conduct. So it doesn't matter. You're not protected anymore because under the preponderance of the evidence, you waived any right under due process and under Sixth Amendment jury trial guarantees to have a jury find facts that are essential to your guilt or your innocence, gangster or innocence. Remember, that's the topic of the show. The defendant, yes, Your Honor. And do you understand that in making those factual determinations, the court will consider all reliable information, which could include hearsay? Oh, just because I heard it, I believe it. There's no evidence to support it. But just because I heard it, I believe it, and I'm going to give you time for that. Now, yes, Your Honor. That's what the defendant says. He's locking himself in. And do you further understand, sir, that you will not later be allowed to withdraw? You understand this. And do you further understand, sir, that you will not later be allowed to withdraw your plea of guilty because either the length or the nature of the sentence that you received? The defendant, yes, Your Honor. Do you understand, defendant, that there is no parole in the federal system, and if you are sentenced to a term of imprisonment, you will not be released from prison on parole? Yes, Your Honor. And do you understand, defendant, you do have a right to maintain a plea of not guilty to those charges and have a trial by jury if you were to choose to do so? The defendant, yes. Do you understand that if there was a trial, you would be presumed to be innocent and the government would be required to prove your guilt beyond a reasonable doubt, which is different from the preponderance of evidence standard? Reasonable doubt. Defendant, yes, Your Honor. You further understand, sir, that if there was a trial, you would have the following rights at trial: the right to the assistance of counsel to your defense, the right to see and hear all witnesses and have them cross-examined in your defense, the right on your own part to decline to testify unless you voluntarily elect to do so in your defense, and the right to have subpoenas issued to compel the attendance of witnesses to testify at your trial. Now, I'm going to stop right there. And the reason why I'm going to stop right there is I'm going to say this here. Most defendants don't go to trial because they don't want to get on the stand and testify in the defense. So they enter into the guilty pleas because they believe when the attorney tells them this here. The attorney tell them, well, you can go to trial, but, I would advise you not to take the stand because of your past criminal history. Trust me. That's the oldest trick in the book. And I say that for the simple reason. If you look at all people who had finances, the aid and system in their defense, most of the attorneys would put them on the stand to testify, unless it was a done deal and there really was no evidence against that person. But if it was 50-50, they're going to tell me you got to get on the stand and tell your story, your side of the story. You got to tell your side of the story. You got to refute the charges. Under the law, any allegation that's made against you that you don't refute is an allegation that's standing, and because you didn't refute that allegation. And furthermore, because an attorney tells you if you get on the stand, they're going to use your past criminal history against you. Well, hello. They're going to use the past criminal history against you anyway. You just heard the court say that to the guy. He said he's going to rely upon any evidence, any testimony. So he's going to rely upon your past criminal history whether you get on the stand or not. It doesn't make a difference. If you're convicted of a crime, if you plead guilty to a crime, if you decide to go to jury trial, man, get on the stand and tell your side of the story. If you're innocent or think that you can beat a case that was unfairly brought against you, tell your story, man. Refute the allegation against you. That's your right under the Constitution. And it would be foolish of you, for lack of a better word, not to testify in your own defense. Let the jury hear you speak. Talk. Even if you enter into a guilty plea, talk. Just don't answer questions. Explain the situation, your side of the story, because they're going to pile on conduct that is going to be detrimental to the sentence that you're hoping to get. So you need to speak to that. Can't nobody speak to it but you. Your attorney's going to get up there and he's going to say some, or she's going to say some things that don't even, fit the scenario of the crime. She's not going to, he or she is not going to support you like she would a client that's well-to-do. I've seen this countless times throughout my experiences within the criminal justice system. They're not going to do that. And you can see it every day yourself. I can call cases out for you. Well, in certain cases, if a defendant's well-to-do, that attorney will bend over backwards for that defendant. Plead every rationale that's legally available to that defendant. In your case, they're not going to say much of anything. And that's a sad testimony to what is called effective assistance of counsel. Moving on. Do you also understand, defendant, if you were to decide not to testify or put on any evidence, the government could not argue or use those facts or circumstances against you? Yes, Your Honor. Do you understand, defendant, by entering a plea of guilty, if your plea is accepted, there will not be a trial and you will have waived or given up your right to trial as well as the other rights associated with the trial that we have just discussed? Yes, Your Honor. Defendant, do you understand that under count 1 of the indictment, if there was a trial, the government would have to prove that you knowingly and intentionally combined, conspired, confederated, and agreed, listen, with defendant 1, 2, also known as 3, 4, 5, 6, and 7, to distribute and possess with intent to distribute a mixture of substances containing a detectable amount of methamphetamine. Excuse me. Yes. Do you understand the government would also have to prove that methamphetamine is a Schedule II controlled substance under the law? What does that mean? What is a Schedule II controlled substance under the law? That's the substance that can get you life imprisonment, unbeknownst to you. Yes, Your Honor. And do you further understand, defendant, pursuant to the charge under count 1, the government would have to prove the amount of methamphetamine. These are elements of the offense that he was charged with under the indictment. Prove the amount of methamphetamine involved with 500 grams or more. That's just the basic minimum under the charging indictment that's charged under 21 U.S.C. 841, 21 U.S.C. 846, conspiracy and the controlled substance statutes. Yes, Your Honor. And do you understand the government would have to prove that the actions of this conspiracy occurred on or before the 1st of 2005, September the 3rd of 2005, within the jurisdiction of the Western District of Missouri? Yes, Your Honor. Defendant, did you in fact knowingly and intentionally conspire with others mentioned in the indictment to distribute and possess with intent to distribute a mixture of substance containing a detectable amount of methamphetamine? Yes, Your Honor. Are you aware, sir, that methamphetamine is a Schedule II controlled substance under the law? Yes, Your Honor. Was the amount of court's asking him this question now. Ain't but two things to get caught by the mouth. Remember what I said. Was the amount of methamphetamine involved in this conspiracy 500 grams or more, sir? Yes, Your Honor. And did your action in distributing and possessing with intent to distribute this methamphetamine occur on or before February the 1st of 2005 and September 3rd of 2005? Yes, Your Honor. And were these their actions of possession and distribution, possession as well as possession with intent to distribute, which occurred in Kansas City, Missouri? Yes, Your Honor. Are you aware that Kansas City, Missouri is within the jurisdiction of the Western District of Missouri? Yes, Your Honor. The court addressing the prosecuting attorney. Do you have any further record you would like to make in reference to count 1 of the indictment? The prosecuting attorney. No. Addressing the defense attorney. Do you? No. Defendant, under count 2 of the indictment, are you aware the government would have to prove that you knowingly possessed and in affecting commerce firearms and ammunition, which were Smith & Wesson 38 caliber revolver, serial number, a Beretta semi-automatic caliber pistol, serial number, and a Taurus 45 caliber semi-automatic pistol, and assorted ammunition? Now what that means is for the consecutive 60 months that the court is going to impose against this defendant. And that is, the only way they can do that is they have to show, the government does, that that firearm traveled through interstate commerce. A lot of people ask, what is interstate commerce? Well, interstate commerce is commerce. And you have to look that up, the word commerce, to understand what that is. So that means that anything that travels through commerce, you're affecting it through illegal activity. And this is why the feds step in. They step in because you have affected interstate commerce, which gives them their jurisdiction to prosecute you. So when you sell cocaine, if you can't prove that cocaine was born and raised in Des Moines, Iowa, it's automatically assumed it comes from a different country. And it traveled from that country all the way to Des Moines, Iowa. And in that process, it had an effect upon interstate commerce. So this is what gives them their jurisdiction, to prosecute you, commerce, because you affected it. The first 2 guns were ones in my possession. Okay, here's the defendant. He's speaking now. The first 2 guns were the ones in my possession. Listen to the defendant now. The other one was not in my possession. Thank you. The Smith & Wesson caliber pistol and Beretta semi-automatic 25 caliber pistol were in fact in your possession? The defendant, yes. Are you aware the government would also have to prove you possess those weapons on or between February the 1st of 2005 and August the 5th of 2005 within the jurisdiction of the Western District of Missouri? Yes. Are you further aware, defendant, the government would have to prove additionally that Okay, defendant, you have stated to me that you did in fact possess the Smith & Wessons and the 35 caliber revolver and the Beretta 25 caliber pistol. Is that correct, sir? Defendant, yes. The government attorney. Do you have information those weapons were manufactured somewhere other than the state of Missouri? The government attorney. That is the information, Your Honor, because that's the element they have to prove in order to convict you of being in possession of a firearm, because it had to travel through interstate commerce. And in Missouri, I'm not aware of any factories that make Berettas or any other type of revolver. So they claim because the steel that's utilized to make these weapons had to travel through interstate commerce or come from a different state, that revolver or MAC-10 or AK-47 or whatever it is you might be in possession of travel through interstate commerce, so you affected interstate commerce. So that's why the feds have jurisdiction over your case. So you young men and women out here toting these pistols who are unaware that the state can find the pistol in your car, find it in your purse, find it on your person, find it in your house, and the state can come in and prosecute you. But the feds can come right back and prosecute you for the same case that the state prosecuted you for. So now you have what is called a dual sentence, because you have dual jurisdiction there. The state has the right to prosecute you under their law, and the feds have the right to prosecute you under their law. So you can end up doing a double sentence based upon that. Or in most cases, the feds just come in and pick it up, and the state will let it go, because you're going to get more time with the feds than you are the state. That's been the theory over the last 30 years. So that's why you see the feds picking up so many cases that involve a gun, especially if you got a prior criminal history. They're really going to pick it up. Or if you got a crime of violence in your past, they're really going to pick up those offenses. So as far as the community is concerned, we would again hope and pray that you be a little bit more conscious and kind of mind your senses, so that you don't find yourself in a position that you find untenable to the quality of life you would envision having as you grow older in life. With that being said, the government attorney, that is the information, Your Honor, the defendant. Now, they're asking the defense attorney this question. Do you accept the government's position without even challenging it? These weapons were not manufactured in the state of Missouri. The defendant's attorney. Yes, Your Honor. The court's addressing the defendant. And defendant, do you accept that fact as well, sir? The defendant, yes. Did you possess those weapons on or between February the 1st of 2005 and August the 5th of 2005 in Kansas City, Missouri? Yes, Your Honor. At that time you possessed those weapons between those dates, sir. Had you prior thereto been convicted of crimes for which, sorry about that, adios. Do you have any further record you would like to make in reference to count 2 at the present time? That's a question to the government attorney. Prior to that question, the court asked the defendant, and at that time you possessed those weapons between those dates, sir. Had you prior thereto been convicted of crimes for which crimes you could have been punished by a term of imprisonment exceeding 1 year? Yes. The government attorney said no in response to the court's question regarding any other reference that the government would like to make as it related to those particular crimes. The court asked the defense attorney, and the defense attorney said no. The court at that time said thank you. On the count 3 of the indictment against you, do you understand that the government would have to prove during and in relation to drug trafficking crimes for which you could be prosecuted in court in the United States, which crime consists of conspiracy to distribute and possess with intent to distribute methamphetamine, as charged under count 1 of the indictment? This is where the 924C is going to come into play. Title 18. That's an enhancement, statutory enhancement provision, not a guideline provision. And what that means is that is what creates the consecutive sentence, because it's a statutory enhancement for having a firearm while you was in possession and distributing and conspiring to sell drugs. That's why you get the additional 5 years after the 30 years. That you possess firearms which were, and goes into the explanation of what the firearms were, which I have already explained to the audience. The defendant, yes. And are you aware that the government would also have to prove you possessed those weapons between February 1st of 2005 and August the 5th, 2005, within the jurisdiction of the Western District of Missouri? The defendant, yes. And defendant, are all the facts and information that you stated to me in relationship to counts 1 and 2 true, sir? The defendant, yes. The court to the government attorney. Do you have any further record you would like to make in relation to count 3 at the present time? No, thank you. Do you, to the defense attorney? No. And you further understand in the count 4 of the indictment, the government is seeking to forfeit all property real and personal, constituting and derived from any proceeds you obtained directly and indirectly as a result of the violation under count 1 in the indictment, and specifically the sum of $1,268 in United States currency. The defendant, yes. Are you consenting to the forfeiture of that sum, defendant? The defendant, yes. Do you have anything further you would like to make a record on in relation to count 4? Government attorney, no. The defendant, no. To the defendant. To the charge, the court, to the defendant. To the charge of conspiracy to distribute, possess with intent to distribute methamphetamine, as that charge is more specifically set out in count 1 of the indictment, how do you wish to plead? The defendant, guilty. And to the charge of being a felon in possession of a firearm, as that charge is more specifically set out in count 2 of the indictment, how do you wish to plead? The defendant, guilty, Your Honor. And to charge of possessing weapons during and in relation to drug trafficking crimes, at that charge is more specifically set out under count 3 of the indictment. How do you wish to plead? The defendant, guilty, Your Honor. The court addressing the defendant. I find you are fully competent and capable of entering informed pleas. I find that you are aware of the nature of the charges against you in all these counts, and also aware of the consequences of your pleas. I find that your pleas are made jointly and voluntarily, and further that those pleas are supported by an independent basis in fact, containing the essential elements of the offense charged against you. I therefore accept your plea and adjudge you guilty as charged under counts 1, 2, and 3 of the indictment. And, defendant, the probation officer will now proceed to prepare a pre-sentence report in your case, and when that report is completed, you will have an opportunity to review it and to note any objections you might have to any of the information in the report. When the report is completed, we will set a date for sentencing in your case, and you will have an opportunity to appear here in a court again at that time. I'm going to order you be continued in custody pending sentencing and final disposition in this case. To the defense attorney, is there anything further that needs to be taken up in the defense case this morning? The defense attorney said, may I ask him a few questions on the record? Now, draw for how the defense attorney gets slick. Yes. Defendant, you heard all the judge's questions. You understand everything? Yes, sir. And you and I discussed all these questions before? Yes, sir. I have come up to see you at the CCA and met you at the courthouse? Yes. And I am holding in my hand a copy of the discovery. Did I come to CCA and go through this with you? The defendant, yes. And we had a chance to look at the statements you had given as well as the recorded calls? The defendant, yes. We have talked about the possibility of a suppression hearing? The defendant, yes. And talked about different trial strategies used if we were going to go to trial? The defendant, yes. And basically you realize it comes down to the fact because of your criminal history, it ended up going to trial. The government would file a double 851 motion if you were convicted, which would result in an automatic life sentence. The defendant, yes. 21 U.S.C. 851, that's the enhancement provision of the mandatory minimum sentence. If you had 2, like in this case, it's an automatic life sentence. If you got 1, it could be 10 years, it could be 20 years, it could be 30 years. But if you got 2 of them, you got 2 prior convictions, and the government files a 21 U.S.C. 851, a statutory provision for enhancement of the mandatory minimum, it automatically goes to a life sentence, even if you plead guilty. If they file that against you, even if you plead guilty, you're going to get a life sentence. And you're going to waive all your rights through the guilty plea, and you're not going to be able to get back on that. And I know individuals who have fallen into that trap, unbeknownst to them, at that time, even though it's expressed like this. The defendant, yes. You know the government's original plea offer was that if you pleaded guilty, they would only file 1 851, which doubled the mandatory minimum to 20 years. So they saved him of the life sentence and filed 1 851 and got him a mandatory minimum of 20 years, excuse me. The defendant, yes. The motion was accidentally filed by the government, but it was withdrawn. The defendant, yes. You understand by pleading guilty today, you have avoided any 851 motion being filed. The defendant, yes. They have 1 year in which to file the 21 U.S.C. 851 against you. 1 year. If they don't file that against you, then you are not subject to that 851 enhancement, which doubles your mandatory minimum for one prior conviction. For two, it automatically goes to life. The defendant, yes. We have discussed the timeliness of entering a plea so you get maximum acceptance of responsibility. The defendant, yes. We have gone through the guidelines and statutory minimum and maximums. Yes. Talked about the possibilities of cooperation. The defendant, yes. We have talked about the possibility of the sentence you get, in this case being run consecutive to the state. So he has a state sentence he has to serve also after doing basically what amounts to almost 300 months, if I'm not mistaken in this case. The defendant, yes. After hearing all these questions and after all the judge's questions, do you have any further questions or do you have anything you want to tell the judge today? The defendant, I'm just sorry for the mistake I made. Thank you, Judge. Thank you. And what the attorney was exercising then was to guard himself against the claim of ineffective assistance of counsel on post-sentencing. That was a lengthy diatribe of a guilty plea hearing in federal court for an individual who has been charged under indictment for drug distribution and firearm possession. There's a lot of those cases in federal prison today, and there probably will continue to be a lot more. But it's incumbent upon any individual that is pursuing that type of behavior in today's world to be conscious of their rights, conscious of the detriment it is to throw away rights that can protect you later on down the road. I'm not suggesting or pleading to anybody not to take a proceeding that's in their best interest. I mean, that's an individual decision. And so I don't want it to seem that I'm suggesting that a person should go to jury trial, a person should take a guilty plea. That's incumbent upon that individual based upon the advice of the attorney and based upon the things that that individual defendant or defendants learn. But I am suggesting that you want to be informed prior to entering into any plea agreement or guilty plea. You want to be informed about that. And during our next episode, I'll talk about a different type of plea that allows you to negotiate with the government attorney to get a plea that the court really doesn't have no say-so in. And that too is in the Federal Rules of Criminal Procedure. But if you don't ever get into the Federal Rules of Criminal Procedure and look at those rules, then you won't know that. And you might have the attorney who may not be conscious enough because he's overworked or she's overworked, underfed, underpaid. It's not telling you that because they try to reserve that particular plea for more wealthier clients. So people that are out here dealing drugs don't necessarily get that advice. And that's unfortunate because you can utilize that particular plea to your advantage to where that you don't suffer the type of consequences this individual here has suffered. And as I get into his sentencing transcripts with you in our next episode, you'll see what he has suffered. And now, based upon my information, that individual has reached out. He's tried to invoke the First Step Act and other acts that were conducive to reducing the sentence, but because he entered into that plea, he's serving out the remainder of his sentence. And that's unfortunate because he entered into a plea. And the attorney got on record and also assisted in locking him in to the fact that the attorney advised him, gave him all the information he needed, reviewed all the material that he needed to review. So I did my job. You're the one that got up here and said you wanted to enter into the plea, not me. I didn't force or coerce you into that plea. And these things are essential to, like I said, people out here that are having problems in life, doing this, doing that, trying to make ends meet, and they're criminal. You're setting yourself up for a rude awakening. And I'm telling you from experience. And I would hope that out of this episode that you gleaned a bit of information, a bit of understanding, a bit of knowledge, and that you exercise the knowledge that we tried to impart to you today to stop engaging in activity that could be detrimental to to yourself and to your family and to your community. First and foremost, Rich Moines Productions and ReformCrimeSentencingNow.org is committed to reforming sentencing crimes for nonviolent offenders, but it's difficult to do that when individuals have records such as the record that I described herein, because this dude had 2 prior convictions, was subject to a life sentence in prison for a non-violent offense. So you need to think about that when you're out here doing the things that you do, but you're grown. I'm not here to berate you or criticize you for what you do. I'm just here to inform and try to educate you and hope and pray that you look at your life from a different perspective and move forward in a way that is more conducive to yourself, your family, and your community. My name is Jerome Deering-Bay. I'm with ReformCrimeSentencingNow.org. The producer of this show is Chuck Booten. He's with Rich Moines Productions, and we appreciate you giving us the opportunity to come into your home and share this information, this education with you. And again, we both hope that you glean something from it. Good night.